Welcome, everyone. Thanks very much for coming this evening. We're very pleased to be able to speak to you about our project on contempt of court. I'm Penny Lewis. I'm the Criminal Law Commissioner, and I'm also joined this evening by Dr. Lawrence McNamara, who is the lead lawyer on the contempt project. Just start with a few sort of housekeeping details. So we will be using slides today, as you can see, and we will publish the slides on our project webpage. We're also recording the event, and we'll post the recording to the webpage as soon as possible, hopefully in the next day or so. And we'll email everyone who's attended to let you know about that. The next 3 slides explain our aim in the webinar, a little bit more housekeeping, and what we're going to cover. So the aim of the webinar is really to explain what we're covering in the consultation. And by doing so, we hope to assist you to respond to the consultation, especially by explaining some of our provisional proposals, including those provisional proposals that have attracted particular interest and or have been contentious during the consultation so far. We also want to give you an opportunity to ask questions using the Q&A function. We hope that you'll then give us your views in a response to our consultation, which closes on the 29th of November, and information on how to respond to the consultation is on the project web page. And it's not necessary to answer every consultation question. You can pick and choose those questions that you want to answer. The slides do have a lot of content on them. We're not going to cover all of that in detail, but because we are providing the slides, we wanted to make sure that you have content that you refer to, that you can refer to should it be helpful. And then housekeeping, we are recording this event, and as I said, the recording will be posted to the website. Everyone's microphones and cameras are switched off for all of those who are attending. If you do have a question, please post it to the Q&A. The project team will review it and then publish it to the thread. Given time constraints, we may not publish to the Q&A thread everything that's submitted, and we also may not publish questions immediately, especially if they're about something that we're going to cover later in the presentation. Also, we may not publish comments. We'll focus on questions, but we will read and take account of everything that is submitted via the Q&A. So if you do have a comment, feel free to put it in there. Please don't use the raise hand function. We're only using the written Q&A function today, so we'll lower any hands that are raised. Sadly, our version of this webinar doesn't allow us just to turn the raise hands function off. Right, so getting started on the substance, we'll start with an overview of the project. So the problem with the law of contempt and our aim, the problem that what we've discovered during the sort of pre-consultation phase of the project is that the law is incoherent and often uncertain. Judges and magistrates find it difficult to apply, and it's applied inconsistently, and there's also a lack of transparency. Our aim in the project is to ensure that the law is fair, effective, consistent, and coherent. The project began in 2022. We've undergone a great deal of engagement with a wide variety of stakeholders before we published the consultation paper in order to inform our provisional proposals for reform. We published the consultation paper in July of this year, and the consultation closes on the 29th of this month. This webinar is part of our consultation process. We've also spoken with and are speaking with a wide variety of individuals who are interested in contempt, from judges, lawyers, journalists, academics, civil society organizations, and those who are interested, for instance, in criminal records and data protection. We do that via meetings, events like this, and we also are very pleased to receive written submissions that will then inform our analysis and the final recommendations that we'll make for reform in our final report, which we're aiming to publish by the end of next year. The consultation paper, as you can see, has 12 chapters. It covers a very wide range of issues, and we'll try to speak to all of those matters in this presentation. Right, I'm going to move on then to the first substantive issue, unless anyone has any questions about the sort of structure of the webinar. Okay, so I'll just wait in case anyone has any questions. Okay, so liability. So we provisionally proposed to dispose of the distinction between civil and criminal contempt. We provisionally proposed 3 forms of contempt, and these are general contempt by either publication or conduct other than publication, contempt by breach of orders or undertakings, and contempt by publication while proceedings are active. Obviously, this can encompass a very wide range of ways that contempt may be permitted. We also note that sanctions for contempt need to accommodate that wide range. So that can range from bad behavior in court to a newspaper article to a series of tweets, for instance. I'll briefly outline the elements for each of these strands of contempt. So general contempt by publication will be established by proving publication and that publication caused a substantial risk of a non-trivial interference with the administration of justice, or actually interfered with the administration of justice in a non-trivial way. The fault element for this type of contempt would be proved by intention to interfere with the administration of justice. We think this high threshold is needed in order to protect freedom of expression. Recklessness would not suffice for this form of contempt, and this is why we've separated general contempt into general contempt by publication and general contempt by conduct other than publication, where we do ask questions about whether recklessness should suffice. This would apply like common law contempt while proceedings are active, but it would also apply before proceedings are active and even before proceedings are imminent. General contempt by conduct other than publication, the same conduct element here, although obviously there wouldn't be a publication. So this might include, for instance, disruptive conduct in court or making a false witness statement. The fault element, intention to interfere with the administration of justice, would suffice, but we also ask whether recklessness as to the interference should suffice. Recklessness would be established where the potential defendant knew there was a risk of causing a non-trivial interference with the administration of justice, but went ahead nonetheless, and it would also have to be proven that it was unreasonable to take the risk in the circumstances. Contempt by breach of orders or undertaking. For this, there would be a circumstance element as well as conduct and fault element. So the circumstance element would be that there is an order or an undertaking binding the defendant, and which would include a penal notice, so warning that there was the possibility of contempt liability, which might result in committal to prison. And that would include an antisocial behavior injunction or an ASB. The conduct element would be failure to comply with the order, and the fault element would be that the defense act or omission was deliberate. The defendant knew there was a court order or undertaking and that they were bound by it, and the defendant was aware of the circumstances that made the conduct a breach of the order or the undertaking. This would be like the existing civil contempt, but would be broader. It would cover all breaches of court orders and undertakings, whether an order was made in favor of an individual party, but it would also include a summons or an order binding the world at large. So it would be broader than the existing civil contempt. Contempt by publication when proceedings are active. So this is roughly speaking the replacement for what's currently called strict liability publication contempt. The conduct element would be similar to the existing provision in the Contempt of Court Act 1981. Publication would have to create a substantial risk that the course of justice in active proceedings will be seriously impeded or prejudiced. And then the fault elements would be for the publisher, recklessness as to whether the proceedings were active, or for the distributor, recklessness as to whether the distributed material created a substantial risk that the course of justice in the proceedings would be seriously impeded or prejudiced. So this wouldn't be strict liability with a burden on the defendant to prove innocent publication. We think that given the importance of freedom of expression, the person making the application should have to prove recklessness on the part of the publisher or distributor, rather than the burden being on the defendant. We know that this form of contempt is very significant for the media reporting on criminal cases, and also for the defendant who is on trial. In terms of when this form of contempt would apply, it would apply from the point of arrest. We ask a question, though, about whether that should move to the point of charge. I'll stop there and wait and see if there are any questions on liability. Okay, so interim coercive remedies. Whoops, sorry about that. So what we heard in relation to contempt liability is that in the context of applications for a breach of order contempt, that those applications are often used as a litigation tactic. We also heard that there was little incentive to comply with an order until the final moments before a contempt application or a contempt finding is made. And we, I think, further heard that sometimes there's a need to coerce compliance rather than bringing contempt proceedings which have a more punitive aspect. So primarily in the context of family law and commercial law, there was a feeling that breach of order contempt, or what's currently civil contempt, wasn't really working, that it was being weaponized, used as a litigation tactic, and also not actually achieving what the order was designed to achieve. So we provisionally proposed that there should be interim remedies available to ensure compliance with court orders or undertakings without the court having to make a finding of contempt. The features of this remedy would be that it would be coercive in intent rather than punitive. That there wouldn't be a need for the court to make a finding of contempt, and that the burden of proof would only be on the balance of probabilities. We have heard views that the use of the word coercive, which is the word we use in the consultation paper, might be problematic in the family context, because in that context, coercion is something that is troubling. So we'd certainly be interested in anyone's views on that. The kinds of things we're envisaging are, as interim remedies, are payment by the defendant of a sum of money into court, either by way of deposit or periodic payment, sequestration of the defendant's assets, or impounding a passport or other documents. We've also heard about impounding, for instance, a car or other vehicle as something that might be effective in family proceedings. So we'd be interested in views on that. I am going to stop there and see if there's any questions on interim coercive remedies. Yeah. Sorry. Yeah, thanks very much for the question, Sunny. So malicious falsehood, malicious communication, deliberate dishonesty, they may form parts of criminal offenses. In terms of how that would be treated in civil litigation, as I mentioned earlier, we would see that as falling within general contempt by conduct other than publication. And it then will be up to a party or possibly the court, depending on how the matter arises, as to whether or not that conduct is pursued as a criminal offense or whether it is pursued as contempt. And sometimes that decision is made on the basis of whether the penalties for the criminal offense are sufficient to mark out the seriousness of the conduct. Sometimes judges prefer to go down a contempt route because they feel that better demarcates the interference with the administration of justice that the conduct involves. Any further questions? Okay, I see a question about the legal aid regime from Mark. I'll table that if you don't mind until we get to the legal aid section, and then we'll deal with that there. Thanks, Mark. Great. So contempt protection and contempt powers. So contempt excuse me, contempt protection is what determines which bodies can have contempt committed before them. So we distinguish in the consultation paper between protection and powers. So a body will be protected by the law of contempt if it is exercising the judicial power of the state. Superior courts are inherently protected. Inferior courts, tribunals, and other bodies, at the moment there's uncertainty. The effect of our proposals would be to expand contempt protection to include any of those bodies which are exercising the judicial power of the state. We provisionally propose that there should be a non-exhaustive list of bodies that are considered to be protected for the purposes of contempt, so bodies that are considered courts for the purposes of contempt. And we provisionally propose that that list should include all chambers of the first tier tribunal, magistrates, courts, and the parole board. One issue that has come up in our consultation is the position of ombudsman offices. Our current thinking is that as part of the alternative dispute resolution system, rather than as part of the judicial system, ombudsman offices are probably not appropriately viewed as exercising the judicial power of the state. However, we would welcome all views on that. In terms of contempt powers, this is what determines what a court can do in response to contempt that's been committed in relation to its proceedings. So we provisionally propose that superior courts of record will continue to have full powers to deal with contempt, and that any protected body that is not a superior court of record should have the following powers. The power to refer the potential contempt to the High Court, the Upper Tribunal, or the Employment Appeal Tribunal as appropriate, to deal with the potential contempt itself, but not publication contempt, and to impose sanctions. We also propose that all bodies would be able to refer a matter to the police and up to and to the Attorney General. I'll stop there before I go on to consider the role of the Attorney General. Oh, sorry. Yeah, I can see new questions. That's an interesting question, Sunny. We certainly did hear from judges that they don't like contempt, and one of the sort of groups of reasons that were voiced to us was that they feel uncertain about the procedure for contempt and uncertain about sort of how to handle contempt matters. And so we hope that our provisional proposals will help with that by making the procedure to be used clearer, having it be consistent across jurisdictions, etc. I think the other way in which we suggest that that be addressed is we ask some questions which we'll come to about whether the burden should always be on the applicant to bring contempt proceedings. So that might be another way in which you could feed that experience in your response, and I'll flag that up when we get to that. And thanks for that comment, Joe, about coercion. Yes, we've certainly heard some concerns about the use of that word. Thank you. Just wait for another question. Okay. Thanks, Isabel. Yes. So the question is about whether there should be a definitive list of which courts are protected by the law of contempt. I mean, we provisionally proposed a non-exclusive list because of the possibility that new bodies would be created, and or we might not be able to identify every body that is exercising the judicial power of the state. I think those were our two concerns. We have had some suggestions from consultees that we should also produce or consider recommending a list of bodies that are not protected by the law of contempt, which might go some way to dealing with the uncertainty that you reflect. But certainly interesting if consultees are of the view that we should produce an exhaustive rather than a non-exhaustive list, then that's something that we're certainly interested in hearing about. Thank you. Okay, going to move on to the role of the Attorney General. So the Attorney General has a constitutional role as guardian of the public interest in the administration of justice. And as I'm sure most of you know, the Attorney General can bring contempt proceedings, and indeed often does bring contempt proceedings in cases involving publication. The consent of the Attorney General is required to bring proceedings under the Contempt of Court Act 1981 for what I called earlier strict liability publication contempt. The decision whether or not to bring contempt proceedings, which the Attorney General makes, is not currently judicially reviewable, so it can't be challenged in the court. What we heard from stakeholders who we spoke to before the consultation paper is that the role of the Attorney General as a government minister is inherently politicized, and that might occasionally result in a conflict of interest where the potential defendant in the contempt proceedings is also a politician, for example. So we make the following provisional proposals and ask questions about. We provisionally propose that the Attorney General should retain the contempt function. We ask an open question about whether the Attorney General's decision should be subject to judicial review. So where we feel there's a strong evidence base, we tend to make a provisional proposal. Where the evidence is more mixed, we tend to ask an open question, which indicates that we don't yet have a provisional view, but we're still interested in consultees' views. We also ask whether the consent requirement should be modified. And in particular, we ask whether the consent requirement should be removed, where the potential defendant is a current or former politician. So, for instance, that might mean that one could seek permission from a court to bring contempt proceedings in those circumstances, rather than seeking permission from the Attorney General or seeking consent from the Attorney General. So an example might be a senior government politician publishes a comment on social media during active proceedings, which could potentially amount to what we've described as contempt by publication while proceedings are active, but the Attorney General decides not to bring contempt proceedings. In those circumstances, we're interested in whether or not there should still be the possibility of contempt proceedings without the Attorney General's consent. Other issues that we raise in the chapter on the Attorney General are about the Attorney General's powers to obtain and share information, and that includes publicly accessible information, information held by the police, and information held by social media platforms. We're not going to speak to those here, but they are in the chapter if you'd like to take a look at them. I can see some new questions have come in. Thanks, Sunny. So Sunny's asked a question about contempt in tribunals. So we have made provisional proposals which will mean that tribunals will have contempt protection and they'll have limited powers to deal with contempt. So that will hopefully help with contempt committed in, or the kind of behavior that constitutes contempt committed in tribunals. I think the question about whether all proceedings should be recorded is one that's bigger than the contempt project. It's actually one that we've also considered in our current project on criminal appeals, where there's a question about whether magistrates' court should become a court of record. And we've taken the view, again, provisionally, that that is a question that isn't something which should be decided in the context of an appeals project. I think we'd say the same thing about a contempt project, that if there's a case for recording it, all proceedings, then that's something that should be considered not only in the context of appeals or contempt, but whether there's a case for doing it, given the resources implications, sort of across the board, rather than simply for a contempt purpose or for the purpose of enabling an appeal. Thanks, Lucy. Yeah, I think this is an interesting point. So the concern about this is a question about interim remedies, but I'll I'll loop back. So the concern is that possible coercive powers which might take away a litigant's independence, for example, a car, could be misused. I can certainly understand a concern about that. And we'd certainly be interested in views sort of against that, because I think there's quite we've heard quite a lot of support for the possibility of having that kind of an interim remedy, including the ability to take away passports and driving licenses or vehicles. So if you have concerns about that, then that's really helpful for us to hear. Okay, I will wait and see if there are any questions about the Attorney General. Okay, procedure. So, at the moment, there are a variety of procedure rules which apply based on where contempt is committed. So there are different rules in the civil procedure rules, criminal procedure rules, court of protection rules, and the family procedure rules. That means that there's a variation in how defendants are treated, which causes inconsistencies, confusion, and unfairness. That's what we heard from stakeholders we spoke to. So we provisionally propose that there should be a uniform general procedure in contempt proceedings in all courts, tribunals, and other bodies that are protected by the law of contempt. That procedure, though, should allow for variations that are needed to address potential contempts in different settings. So, for instance, criminal courts have cells. Civil courts may well not have access to cells. So the procedure for something like immediate temporary detention, for example, might have to be different in different kinds of courtrooms with different resources. We also provisionally propose that the various procedure rule committees should consider collaborating to develop a uniform general procedure, either perhaps by establishing a joint working group of the rule committees or a new contempt procedure rule committee. In terms of bringing a contempt application, we currently permission is only required in some circumstances. What we heard was concern in the commercial context that applications for contempt by breach of order were being weaponized as a litigation tactic, as I mentioned earlier, in order to pressure the defendant into settling the underlying dispute. So, for example, where there's a freezing order in commercial disputes and the defendant doesn't comply with that, or only partially complies, that contempt proceedings are being used to coerce the defendant into settling the underlying dispute. A permission requirement would enable courts to filter out cases where there's a more effective and less costly way of dealing with the issue. So, for example, an interim remedy, and would also allow for active case management. So the aim of the provisional proposal here is to reduce costs and delays. We provisionally propose that permission to make a contempt application should be required in all courts where the application relates to breach of an order. And we ask whether permission should be required for applications relating to other types of contempt. We have heard in consultation that in some circumstances requiring permission would have the effect of delaying proceedings and increasing costs. So we'd really welcome responses on these issues, including examples of areas where it would be helpful and those where it may not be helpful to require permission. And then in relation to a point that was raised earlier, I mentioned that we were asking questions about whether the burden of bringing a contempt application for breach of order should always lie with the party seeking to enforce the order. The concern that was put to us in this context is that in family cases where separated parents are reluctant to enforce a contact order because they're worried about what the parent who's not complying with the order will say to the children about the parent seeking compliance. We heard that it might be helpful for the burden not to be on the person, the party seeking compliance, and possibly that there should be a new enforcement body empowered to make a contempt application for breach of an order. So we asked questions about that. We're nonetheless conscious, though, that it's impossible to prevent a parent who's not complying with a court order from saying to the children something about a parent who is seeking compliance, whether or not they are the ones making the application. So we'd certainly be interested in any possible solutions that consultees might have. We also heard that there can be a reluctance on the part of the relevant statutory body. So, for example, an NHS trust to make a contempt application. So we'd certainly be interested in any experience anyone has with those kinds of proceedings. In relation to evidence, there's currently a rule in some courts that witness evidence must be given by affidavit rather than, for instance, a witness statement. And yet the criminal procedure rules allow witness statements. So what we heard is that it can be difficult and burdensome to obtain affidavits. We therefore ask for views on whether, when written statements of witnesses are used, witness statements should be admissible rather than requiring evidence to be given on affidavit. We also ask a question about what happens currently where a court or tribunal directs that a contempt application does not need to be supported by an affidavit. In what form does the court or tribunal tend to direct that the evidence must be provided? So we'd certainly be interested in any experience you have with that. In terms of the criminal evidence rules, we've provisionally proposed that they should be used in contempt proceedings in two respects. So the first is in relation to hearsay. This arose out of the need to respect the defendant's right to examine witnesses against them under Article 6(3)(d) of the European Convention on Human Rights, given that contempt proceedings are considered criminal proceedings for the purposes of Article 6. The European Court of Human Rights has held that a presumption against the admissibility of hearsay evidence complies with this right. So we therefore provisionally propose that hearsay evidence would be admissible only in the circumstances permitted by the Criminal Justice Act 2003. We also make a provisional proposal, which some of you may remember as looking a lot like Section 78 of the Police and Criminal Evidence Act 1984. This arose out of a concern where a person is interviewed by police about a criminal offense and only cautioned on that, but the behavior in question may also amount to contempt. If the CPS decide not to prosecute and instead refer the matter to the Attorney General for contempt, it may be that the person is now suddenly facing much more severe sanctions than they were when they made admissions in interview in relation to the potential criminal proceedings. And there's a concern that the interview that it is not fair to use the interview in circumstances where the person hasn't been warned about the possibility of contempt proceedings. So that for that limited purpose, we suggest a sort of analogy to Section 78, so that the evidence shouldn't be admitted if it appears to the court that it would have such an adverse effect on the fairness of the proceedings that it should not be admitted. I'll stop there and wait for questions on procedure. Okay, thanks, Catherine. That's helpful about affidavits. So that was a comment that requiring affidavits just delays matters and increases costs. And then there's a comment about recording as being helpful. I mean, I think there is a point here about recording. It's also been raised with us in just general criminal context. Journalists would like to be able to record proceedings rather than trying to record things themselves using shorthand, for instance. So it's definitely an issue which is live for us across a number of projects. It's certainly something that we can raise with the Ministry of Justice. Thanks, Joe. Any more questions? Okay. This is a really good question about importing the criminal hearsay rules. The judge has asked, is there not a concern that the application of the Criminal Justice Act 2003 gateways, which come with a significant body of case law, will prove problematic for judges sitting in civil and family courts? I mean, I think that's a valid concern, and I've just seen someone's given it a thumbs up. I think that is a valid concern, and I think there's certainly been from family law and civil law stakeholders some concern about this proposal, and we're certainly interested in views about the workability of it. I think it's fair to say that we will need to look at whether or not this based on the evidence that we get during the consultation, whether we think this is a workable position. And if not, then where we go with that, because obviously these are proceedings where the defendant may end up in prison. They are criminal for the purposes of Article 6. So we do need to ensure Article 6 compliance. So it's certainly something we're looking at, but I mean, I suppose the most helpful arguments would be ones which explain how it's possible to comply with Article 3 without importing all that criminal hearsay case law, Article 6. Because that is the concern. So, when we're considering where to take the recommendation in this regard, we need to get somewhere that ensures that we are compliant with Article 6. I'll just look. Okay, so I think this next question is actually about sanctions, which we're going to come on to later, so I will deal with that then. And then an interesting question about disclosure. I think that's something that hasn't really come up. So I think the answer is no, we haven't really thought about that, but it's certainly something we can take a look at. Thank you, Mark. That's really a helpful suggestion. Good point. Perhaps one for the procedure rule committees to consider, but we'll certainly take a look. Great. Okay, so I'm going to hand over to Lawrence, who is going to talk about legal aid representation and costs.
Thanks, Penny. So the first thing I'll just speak to for a moment is legal aid. So I will start by referring back to the question Mark Livingston asked a little while back, which was about whether legal aid would apply where there is an application for an interim remedy. The answer to that is we would be interested in your views. It's not something we have reached a position on one way or the other. And it is if you like, interim remedies are part of the bigger jigsaw we're putting together. So whether it is, for instance, I think it's a great point and something we would very much welcome views on. Similarly, if there are other parts of that jigsaw you think look a bit where you can't work out how you would reconcile A with B, we're very open to that as well. So I'll turn then to the legal aid issues that we've looked at here. So one we want to highlight in the consultation paper is means testing. So the current position is that defendants in contempt proceedings receive criminal legal aid regardless of whether those proceedings are in a civil or a criminal court, or whether they are for civil or criminal contempt. So means testing, at the moment, a contempt defendant in a criminal court their legal aid will depend on their financial resources. It is means tested. A contempt defendant in a civil court will receive legal aid regardless of their financial resources. So the position is quite different there then. And in that civil context, there are, possible sort of examples of unfairness that we include in the summary consultation paper. So, for example, you might have a potentially vulnerable defendant on a low income who has breached an antisocial behaviour injunction and they're facing a committal order in the county court. That defendant will receive legal aid. You might also have a wealthy person who lied on a witness statement as part of an insurance claim, and the insurer commences a contempt application in the High Court. And legal aid costs there might run to tens of thousands of pounds. That person will also receive legal aid. If you were to move to means testing in the civil courts, then neither of those defendants, that is, the person who's breached the ASB or the person defrauding the insurance company, neither of those may get legal aid. And there are arguments for and against means testing for all. In favour of means testing at all, well, then the approach is not dependent on just the venue you happen to be in. It would reduce legal aid exposure in the High Court scenario around the insurers. Against that, though, you may have means testing. It may have adverse consequences for defendants who fail the means test but are faced with a contempt application made by a well-resourced applicant. The provisional proposal we've made is that means testing should apply in all contempt proceedings, but we also ask in the same consultation question whether there are categories of cases that should be carved out as exceptions where means testing should not apply. So we would very much welcome views on that, both on the overall position and on any carve-out possibilities. I'll turn then to the first of two slides on costs. So the first of these is on costs generally. So currently, where contempt proceedings occur in criminal courts, costs against a defendant are limited to the amount they have the means and ability to pay. In civil courts, there's no requirement that the court must consider the defendant's means when making a cost award. There is some qualification to that position in the civil courts. They may take account of means in considering whether costs are reasonable and proportionate, when imposing a penalty, where there's an interference with ECHR rights. The proportionality assessment requires the interference as a whole is proportionate. So there must be a consideration of the relationship between costs and penalty. However, that difference is still there. And so we ask, it's an open question, not a provisional proposal, where a court is determining costs in contempt proceedings commenced on application in a civil court, should there be a requirement the court consider the defendant's financial resources? The second slide just here on costs relates to legally aided defendants. Let's go forward if we can.
Oh, sorry.
Yeah, that's right. So the next slide on legally aided defendants. The current position is that a legally aided defendant in the criminal courts receives criminal legal aid and they have costs protection. And that's under criminal law and procedure. A legally aided defendant in civil proceedings other than contempt receives civil legal aid and has cost protection under LASPO. But a legally aided defendant in contempt proceedings in the civil courts, they will receive criminal legal aid that don't have either of the above costs protections. And as the courts have described it, this means those defendants are put in a worse position by the decision that they should receive criminal rather than civil legal aid. And so our provisional proposal here is that costs protections for legally aided contempt defendants in civil courts should exist, and in short form, they would align with the cost protections under LASPO. So they are sort of a few of the main points out of our chapter on legal aid costs and representation. I'll just wait for a moment and see if there are questions coming through on that. New posts. Okay. So Mark. Just reading Mark Livingston's question here. Mark is suggesting, is it not better to keep it non-means tested? Clients were time of the essence. Clients will assume they aren't entitled to legal aid, end up as litigants in person, accused of breaching a freezing order. Solicitors may not want to know details of finance at this stage, conflict them. I mean, I think, Mark, they're exactly the kind of points we want to hear. It's putting a bit of a depth around those issues of the for and against arguments. So again, we would very much welcome views about that position. And as I read Mark's position there, it is, well, let's actually retain non-means tested rather than put some kind of carve-out option. If you're submitting a response, it might also be worth considering whether you would like to say, and this applies to anyone sort of who's submitting a response, you might say, well, look, let's keep it not means tested, but if you were to means test and have carve-outs, these are the areas of carve-outs potentially. Catherine has said, the confusion in the, I think the question of the unrepresented litigants, we do look at some of this in the consultation paper. I think one of the real challenges we have here is the extent to which contempt of court reform and within, including around legal aid, within the ability of what the Law Commission is able to say in that regard, what changes would start really helping that difference and avoiding unrepresented litigants, I think would be one of the things we'd be interested in people, again, nailing down there a bit. And the disparity in criminal and civil procedures, I think, goes back to some of our earlier procedure points there. I'm not sure if there's other things. No, let's, I think, move on to sanctions then, Penny.
Thanks, Lawrence. Under the current legal position, the maximum sanctions for a superior court are 2 years committal to prison and an unlimited fine, and for an inferior court, generally 1 month committal to prison and a maximum fine of £2,500. The county court, though, is treated as a superior court for the purposes of sanctions, and we're aware of considerable variation in the family court depending on what level of judge is involved. Tribunals and other bodies may not impose sanctions unless they're superior courts. So what we heard was no evidence of a need to raise current maximums, and but that there should be a wider range of sanctions options available, particularly a need for community sentences. So what we provisionally propose is that there should be no change to the existing maximum for superior courts of record, so 2 years committal and an unlimited fine. Remember that the maximum have to be able to be appropriate for the most serious kind of conduct. So we might think of conduct like assaulting a judge or a member of court staff, or a member of the jury or a witness. That's the sort of conduct that would be likely to get the sort of maximum committal. We also provisionally propose a much wider range of sanctions options for superior courts. We provisionally propose that pre-sentence reports should be available, as they are in the criminal courts, that it should be possible to suspend fines, and that community sentences should be available. We continue to propose that the county court should be treated as a superior court for the purposes of sanctions. And then in relation to inferior courts, we argue that there should be some consistency, so they should have the same sanctions powers across all of the inferior courts, tribunals, and other bodies. But we ask whether there are any cases that should be treated differently. We also note that where an inferior court, tribunal, or other body encounters a matter it considers that it may require sanctions that are only available to the superior courts, it should be possible to refer the matter up to a superior court. We're interested in views, though, on whether or not there need to be differences, which would sort of mean not having a consistent approach across all inferior courts, etc. We're also interested in whether there should be any mirroring of the current approach in the family courts, where the maxima depend on the type of judge who's involved. So if consultees feel that there's a strong case for that, then it'd be really helpful to us if you'd let us know. In relation to antisocial behavior injunctions, what we heard is that many people who are committed for contempt are committed for breaches of ASBEs, and that many of those people suffer from mental health vulnerabilities. We talked to a number of lawyers and academics about this cohort. We heard that they're vulnerable, often living in poverty and or with mental illness or disorder. They may not understand the meaning of an ASB or the consequence of breaching it. And we were told very strongly that imprisonment is often inappropriate and disproportionate. We would certainly welcome more data. If anyone has data on how many people coming before the courts for ASB breaches have vulnerabilities and what those vulnerabilities are, and the effects of those vulnerabilities with respect to the circumstances of breach and the prospects of future compliance, and how the courts take those vulnerabilities into account currently, that would be really useful. But we don't propose that committal should be removed as a sanction for breach of an ASB. And the reason for that is that there will be cases of egregious breaches of ASBs where all other possible sanctions have been explored to no avail, and without an order of committal, there might be no effective way of preserving the integrity of ASBs or the administration of justice. We do recognize the importance of pre-sentence reports in this context, and we have, as I said on the last slide, made a provisional proposal that they should be available. We also make a provisional proposal about medical reports and mental disorder. So we provisionally propose, in terms of alternatives, interim remedies, which I've already described, the wider sanctions options, including pre-sentence reports and community sentences, and that where committal is being contemplated and the defendant is or appears to be suffering from a mental disorder, the court should be required to obtain and consider a medical report unless it considers it's not necessary to do so, and must consider other information on the defendant's mental condition, including the likely effect of committal on their mental condition and on any treatment. In terms of sentencing guidelines, what we heard is that courts have had to develop different guidance for sentencing in specific courts and contexts, and that the absence of sentencing guidelines leads to inconsistencies, which is especially a problem for courts who don't ordinarily sentence, so outside of the criminal courts. We spoke to the Sentencing Council and the Senior Judiciary, and their view was that guidelines should be developed by a judicial working group, which draws together a range of expertise on sentencing contempt in different contexts. We think this provisional proposal is likely to be taken forward, given that it was indeed a provisional proposal that the judiciary made to us, really. So we look forward to that. Other sanctions issues are considered in the chapter on sanctions, including home detention curfew. And we also asked some questions about children and young people. I'm going to move on, but there is, as you can see, a slide on this, and we'd certainly be interested in views on either of these issues. Right, I'll stop there in case there are any questions on sanctions. And in fact, I'm going to answer the earlier question by Sunny on sanctions, which asked about whether we consider the differences between sanctions where the contempt is something that burdens the court in some way, so some form of perhaps contempt in the face of the court, and sanctions where the effect of the non-compliance with breach of order, with an order or undertaking, for instance, is primarily felt by a party. We consider that the range of sanctions that we've provisionally proposed should allow the court to be able to respond to both of those scenarios. It wasn't something that we heard from stakeholders that there needed to be a different range of sanctions for those different scenarios, but we'd certainly be interested in views if anyone thinks that there do need to be different sanctions. In some ways, our proposals on interim coercive remedies or interim remedies are designed to deal with the concern that breach of order or undertaking primarily injures the party, that what they're designed to do is to coerce compliance with the order. Right, in terms of new questions, that's really helpful, Catherine. Yes, we've also tried very hard to obtain data on ASB committals more generally, and we have not been successful. Mark, that's an interesting question. So at the moment, contenders don't qualify for release after 40% of sentence, unlike offenders in relation to criminal offences. We didn't explore this before we published the consultation paper, because I think this early release program postdates the publication of the consultation paper. So we can certainly try and explore whether the decision not to include contempt prisoners, was intentional. I think the answer to that at the moment is we don't know. But we do know that you're right, that they're not included, and so they are only eligible for release after 50%, as we understand it. But that's something that we could certainly explore with the Ministry of Justice, and I suppose it could change in the same way as, you know, we propose law reform on other issues, recommend law reform on other issues. We could also recommend law reform in relation to that. So thank you for raising that. That's very helpful. All right. Do we have time to deal with appeals? Very, very quickly. I'll just basically flip through the slides. So because we are running out of time. So we have made some provisional proposals about appeals. One is to require permission. And then you can see on this slide that we suggest that you go to the consultation paper if you're interested in routes of appeal and have a look at the diagrams that we've included there, particularly figure 3, figure 4, and figure 5, the latter two being the two options for reform. So if you're interested in appeal routes, then please do take a look at those figures, and then do let us know your views. Right. I'm going to assume that there aren't any questions on appeals and hand over to Lawrence, who's going to talk about data transparency and information.
Thanks, Penny. So just given the time, just a few points around data and transparency. Catherine made the point in the Q&A before about the lack of data. There is enormous data gaps around contempt. If we wanted to know how many people are in prison for contempt, we don't. That is one of sort of an example of the data gaps, but they are huge. It's really hard to find data, and we look at this quite a bit in the consultation paper. So one of the things we propose is that there should be annual publication of data in relation to contemners that are received into prison. There is some annual data, but it doesn't break down in a way that might be helpful. So we've suggested what we think would be useful, at least as a starting point for some of the data that can be disaggregated. We think there would be real benefits to enhanced data recording. You know, it might help us know if sanctions work. It provides a better basis for research. It also might assist judges in sentencing those against whom there have been multiple contempt findings. It might help inform the Attorney General's office in making decisions in the public interest about whether to bring proceedings. The second aspect I just want to look at on transparency is around the publication of judgments. So there is some publication of judgments at the moment, but there is variation in the procedure rules. There's inconsistency in what judgments are published. There's a lack of transparency. And we provisionally propose that judgments should be published where a court makes an order of committal for contempt, whether immediate or suspended, and then those judgments should be sent to the National Archives for publication on the Fine Case Law Service. Something people may wish to engage with on this in responses is whether that is the right marker for when a judgment should be published. So some of the procedure rules require any judgment to be published, whether or not there was a committal. Others only require committal as your marker. There are resource implications for this, of course. It's also been pointed out to us in consultation that sometimes, even if there has been no committal and no finding of contempt, that can be a really helpful thing to be recorded in a judgment. That doesn't mean, of course, you might, put differently, it might be that you reach a position where there are a requirement to publish some judgments and a discretion to publish others. But we would welcome any views around the publication of judgments. The last of the slides in this area that we'll just turn to is on criminal records. So currently some contempts may be entered onto criminal records, the police national computer, if you like, and appear then on a criminal record certificate. The practice is inconsistent. Our provisional conclusion in the consultation paper is that the law as it stands does not actually permit contempt to be entered onto a criminal record. And this is partly because contempt is not a criminal offence. The provisional proposal we make is that a finding of contempt and any associated sanction should never appear on a criminal record certificate. We are not saying they shouldn't be recorded. We say there should be recordings of contempt findings, but not a criminal record. But we would be very interested in any views on this, because it might be that there is a case that some consultees think, look, actually, there are some contempts should be recorded and available on the police national computer. For instance, contempts which engage family violence issues. And so we would very much welcome views around those issues. We make a range of other sort of provisional proposals in relation to transparency in other parts of the CP, but I'll just pause there in case there are questions on these issues.
There's one question from Joe, which maybe I'll jump in because I've had a chance to read it. So that would be really useful, Joe. We very much welcome that. We've had some engagement with Jonathan Hall, Casey, the independent review of terrorism legislation, who's been raising similar issues with us about how much information police can and should release and what to do in circumstances where traditional news media are playing by the contempt rules and others on social media are not. So I think that's definitely a live issue for us in relation to contempt by publication when proceedings are active or even contemplated. And we'd really value a policing perspective on that. Would be extremely helpful. And we're very happy to set up a separate meeting if that would be useful.
Thanks, Penny. So I'll just address a couple of things. Celia Kitzinger has made observations about the absence of data collection in the Court of Protection, whether hearings are listed, and I think the listings issue is a really interesting one as well, and one that I don't think we've been as focused on as the outcomes. We have been made aware in the Court of Protection and family contexts that there are sort of anonymity and privacy issues that need to be taken into account in those contexts. But certainly, we're alive to those concerns, and we would very much, again, welcome views on that. Sunny has asked a question about this sort of empirical evidence, which I'll come to in a moment. But I think generally, again, that point about the value of transparency is one that we turn to several times in the CP. So that brings us to a close with this. And I just want to make a few sort of points in closing. One is, first up, thank you to everybody for questions. There's a few that have not been sort of published for reasons of time, but just in general terms, One of the issues that's come up both in the questions in the thread and a couple we haven't put up are the weaponisation of contempt and the potential misuse of it and how we are combating that. Certainly the permission requirements, for instance, in where it's used as a tactic in commercial litigation, one of the issues we raised, the burden of making an application, where that should fall, means testing for contempt. Mark raised an issue about that. So there are a range of ways we are sort of endeavouring to engage with those. Mark also raised a concern about cost recovery at legal aid rates. Thanks for that, Mark. That is one we'll sort of have in the background of our considerations as well. So just to go then through to the sort of in closing here about responding to the consultation. Closes on the 29th of November. Our project webpage has information about how to respond. It has the summary CP. It has other documents and videos, a little bit about protests. And again, we're endeavouring to sort of, where we have an opportunity to put up short summary pieces. So keep an eye on the webpage. You don't need to answer every consultation question. I feel it is very brave of anyone who attempts the whole 137, but you can answer 1, 2, as many or as few as you like, and that is completely welcome. You can respond using the online portal or by email. If responding by email, there's a bit of guidance there about what makes for a helpful response there. I think overall, a couple of things just worth finalising, saying finally are, one is that what we keep talking about throughout the webinar and the consultation paper is provisional proposals, and they are exactly that. They are not recommendations. That's our aim in consultation, is to get evidence, to get information. And if you've got evidence about how things work, about what's going on, yeah, please include it in a response. That's really, really helpful for us. And the other one is, we really want to hear from you. That's really important to us, and it makes a real difference to how we go about consultation and how we go about, in particular, what then comes out of that analysis. So thank you to everybody for listening, for some great questions. The slides and the recording will be available in the next couple of days. I don't know, Penny, is there anything you wanted to add?
No, just to say thank you everyone for attending. We're really grateful for your participation, grateful for the questions, and we look forward to many consultation responses.
Thanks so much. See you later.